So, what's the formal criminal justice process look like? Well, we can think about the process in reference to the 15 steps in the formal criminal justice system. The first step is initial contact. In most cases, this is where a police officer observes a crime being dispatched, or a crime and is dispatched to a crime scene. The next step is, of course, investigation. This is collecting evidence, witness statements, creates the concept of probable cause, and then ultimately gives the justification for arresting a person suspected of a crime. That leads us into the arrest. This is a legal condition wherein any individual's freedom is restricted by the police. This is not to be taken lightly in the United States, where we as individuals are perceived to have freedoms that prevent us from being incarcerated. All arrests must be based on probable cause. The in presence requirement rules that most times a police officer has witnessed something personally, and then results in a misdemeanor or a felony, and of course results in the arrest. Custody is the next step, or step 4, if you will. Following the arrest, suspects are detained, and in some cases the investigation process continues. But the suspect is now being held within the criminal justice system, and they're no longer treated the way they would be if they were not in the criminal justice system. Charging, that's the formal process wherein the police present the evidence to a prosecutor, and usually by mutual agreement, a decision is made on the most appropriate offense based on the available evidence. This sometimes involves dropping the case, but in many cases it does not. Next step is a preliminary hearing, or possibly a grand jury. You've been hearing a lot about grand juries with the Mueller investigation over the last couple of years. That's where this process starts to come in. Depending on the jurisdiction, during this step, the evidence is reviewed objectively. Once again, this is where that science comes in and law. We need to see things without allowing our emotions to cloud our reason. We need to see them objectively. The initial charge may be accepted, or it might be modified, or it might be nullified. Next step, arraignment. This is where a formal process wherein the suspect is informed of the charges and asked to enter their plea of guilty or not guilty. All this stuff you're very familiar with these days. Much more familiar with it than maybe I was when I was growing up, simply because most of our TV shows deal with this entire process. And that process is being socialized through the media that we consume. And so really, this shouldn't be a surprise. Next step, bail and detention. This is, once again, a formal process. All of this is formal, wherein the decision is made on whether to release the suspect from custody pending trial. Bail is a payment to the court in cash or some sort of tangible property that ensures the suspect will return for adjudication. If you were following the Epstein sexual assault case that recently was being played out in the news media, ultimately it results in him committing suicide, and he was denied bail. The court decided that he was too much of a flight risk, and he had enormous amounts of wealth, and so they chose to keep him in prison. Plea bargaining, a formal process wherein the prosecutor and defense attorney bargain for a change in the defendant's plea. The defense attorney, of course, wants the least punitive outcome, and the prosecutor wants to avoid a trial to ensure the most punitive outcome. The strength of the evidence against the defendant often determines the outcome of this process. As we've seen over the last 5 or 10 years, plea bargains are being overturned because of new evidence that's brought to bear on the case. And in many respects, that new evidence has to do with DNA testing. Trial adjudication, another formal process wherein the prosecutor presents the evidence and attempts to remove reasonable doubt of the defendant's guilt. This is an adversarial process where the defense attorney is of course expected to refute the prosecuting attorney's evidence, and both parties are working against each other. That leads us into sentencing and disposition. So if convicted, the offender is sentenced to pay a fine or a term of imprisonment or probation. Of course, this is the end of every crazy trial you've ever seen on TV. What's going to happen? Do they win? Do they lose? Are they not going to jail? Are they going to jail? And then, of course, that leads us into an appeal. And post-conviction remedies to a redress from the process that went before. Following conviction, the defense may ask the court to set aside the verdict or ask a higher court to reverse the decision. So if you don't get your appeal, well, you're heading to correctional treatment. Even if you do get your appeal, the appeal process takes some time, so you're ultimately going to correctional treatment. This happens after sentencing. The offender is placed in the custody of the correctional system, institutional or community-based. While there, the offender may receive rehabilitative training, or they might not. Ultimately, this is going to end in release. After the offender has served their time, he or she is released and can return to society. Most offenders are released early to parole, and that means we got to deal with them on a post-release. In some situations, ex-offenders are required to continue treatment and supervision in a community-based program like a halfway house or a pre-release facility. This is trying to address the recidivism rates and keep the ex-incarcerated individual moving in the right direction. You can think about this process in reference to like an assembly line. Some view the criminal justice process in this way, like a conveyor belt. With an endless supply of cases moving from one stage to another. Others view it as a funnel where you have this large number of cases entering the system, and for numerous reasons, cases exit the process, and then the relatively few cases actually progress through the entire process. There's also the informal criminal justice process. Traditionally, the criminal justice process is viewed, as I talked about throughout that 15-step process, in formal language. But in reality, cases are often settled informally through cooperative agreements, like plea bargaining, or discretion based on the judge, or desire to preserve resources for more serious crimes. So that courtroom work group can use cooperation rather than conflict in order to process this high number of cases, and ultimately that's the norm. So the prosecutor, the defense attorney, the judge, and other personnel cooperate to streamline cases through the criminal justice process. And because of that, upward 80% of all felony cases and over 90% of misdemeanor cases are settled without a trial. Now, this can be a positive or this can be a negative. It's just the way it is. It creates a series of levels in an effort to look at the criminal justice process. There are 4 layers. Level 1, the celebrated cases. Level 2, the serious felonies. Level 3, the less serious felonies. And then level 4, the misdemeanors. The smallest number of cases receive the most public attention. And those are the ones that we think the system is representative of. But that's just not the case. We can see this in reference to the wedding cake model, which was proposed by Samuel Walker. In that he discusses how the smallest layer of the cake gets the most attention because it has that statue of the bride and groom on it. It's what we gravitate towards. It's what we like to see. Likewise, the smallest number of cases in this case receive the most attention. Like I said, the wedding cake is a good way of thinking about the multi-layers of criminal prosecution in this system. There are a variety of perspectives on justice: crime control, rehabilitation, due process, non-intervention, equal justice, and restorative justice, all of which you may or may not agree with, some, all, or any. The crime control perspective, this is that we should deter crime through the application of punishment. The more efficient the system, the greater is its effectiveness. And in this case, the justice system is not equipped to treat people, but to investigate crimes, apprehend suspects, and punish the guilty. So we're collecting all the people that are doing crime, but we're not doing a whole lot of rehabilitation in the process. The rehabilitative perspective is designed to care for people who cannot manage themselves. It's better to treat than to punish. Of course, criminals are society's victims. Helping others is the American way, and convicted criminals can be successfully treated and reintroduced into society. Due process is designed to provide a fair and equitable treatment for the accused. Every person deserves the constitutional rights and privileges that each other person gets. Constitutional rights and democratic ideals take precedence over punishment, and decisions must be carefully scrutinized to avoid errors. Now you can imagine all of this stuff is coming together over time. This here can come out of a social justice perspective, the civil rights period, where people are struggling to be treated as equals. Non-intervention, criminal justice agencies should limit their involvement with criminal defendants. Labeling individuals as criminals is harmful and disruptive and really hard to shake. Stigmas lock people into a criminal way of life, and what the system should really be doing is decriminalizing, diverting, and deinstitutionalizing the justice process. The equal justice perspective, this is where equal treatment should be given for equal crimes. Decision making is standardized and structured by rules and regulations. Individuals' discretion is reduced and controlled, and inconsistent treatment produces ultimately a disrespect for the system.